everyone, it's Stacy Clark, and I'm glad to have you here for another episode of Legal Talk. Who knew, but October is National Estate Planning Awareness Month. Woohoo! So today, we're going to talk about that subject. Having an estate plan ensures that your wishes for your estate are carried out when you pass away, or while you're alive if you become unable to make decisions for yourself. Today, we're going to talk about why estate planning is needed for those of you without a will, who are over 18, and for those of you with a will, why you should use this special month as a good time to review your choices and directions in case things in your life have changed. We're going to talk today about things you need to do first to plan for your life while you're alive. And then we're going to also talk about planning for your death. Happily, I have brought one of the area's leading experts to help us understand this very, very important area. Lisa Shearman is the chair of the Estates and Trust Department of the law firm Hamburg, Rubin, Mullin, Maxwell, and Lupin. And she's also the president of the Montgomery Bar Association. In addition to that, she's also a fellow of the American College of Trust and Estate Counsel, which is a very prestigious honor to have been bestowed upon her. She's been helping men and women with their estate planning and tax reduction strategies for over 30 years. When not practicing law, she donates her time to something called Wills for Heroes, an organization that helps first responders, fire, police ensure their estate plans are in place for free. Hi, Lisa.
Hi,
so
Stacey.
Glad you're back.
Thanks for having me again.
I'm so glad we're going to conquer this topic today. I have so many questions for you, but I think the best thing to do is start off with why is estate planning necessary for families and individuals?
Well, an estate plan is going to give direction to your family as to where you want your assets to go when you pass away. It's a little more involved than that, but I mean, that's, kind of the basic concept. It gives direction. It also can set up trusts for younger, beneficiaries. We also include powers of attorney in our estate planning, and often we include trusts. And so in combination with that, we're also guiding them on beneficiary designations, ownership of property, and for people who own their own business, succession planning.
Got it. So what are the consequences of not coming to see you and having your wishes put into paper?
Well, that's a loaded question.
I know. What could happen? What could happen?
There's so much that can happen if you don't have your plan properly in place. Just as an example, we're handling an estate right now of a young man who died in his late 40s without a will, with a very significant estate. He had one child who was over the age of 18, one child who's under the age of 18. And now these two children who most likely would have had their inheritances held in a trust are now going to receive their inheritances. The 21-year-old is going to receive their inheritance immediately, and the younger child, I think is 16, will get theirs at 18. And we're talking about $5 million each.
Wow.
And so at this point, the other very sad fact to this is that he was engaged, and his fiance will get nothing because they didn't have any legal relationship at the time. So there's no guarantee through our intestate laws to provide for her. So it really is important, when you're thinking about those things. And a lot of people think when they're young that they don't need a plan, but you look at a scenario such as this one,
right,
where all of a sudden you have young children inheriting significant amounts of money without any necessary guidance, and you have someone who was very close, obviously they were going to get married, and is not going to inherit anything with his passing.
Yeah, that's so interesting, because I know one of the things you've talked about is this affects families, and families come in all different sizes right now. So if people are in a relationship, whether it's a man and a woman or whether it's a same-sex relationship for a long period of time, they're affected by not having something in place, right?
Right, because if you don't have written documents that direct where you want your property to go, or if you haven't set up your beneficiary designations appropriately, then the law sort of writes your will for you. Pennsylvania has what we call an intestate law, and that directs who receives your property and in what amounts based on the legal relationship that you have. So if you don't have a legal relationship,
Like a marriage.
Right, a marriage, or you haven't directed, in a will. I mean, if you aren't married, there are a lot of couples who, aren't getting married, but, are living together and, have these relationships. And without having a document that says I want it to go to, my, boyfriend, girlfriend, fiance, whoever, even if it's just a close friend, it's not going to get to that person without having direction in a written document.
Mm-hmm. I see that as so important. So tell us about the main components of an estate plan.
Yeah, so estate planning, comprises, if you think, I think a lot of people think of an estate plan as my will, my financial power of attorney, and a healthcare power of attorney. And they are certainly the primary documents that we're doing for most of our clients. However, it could include trusts. It could include, buy-sell agreements when we're talking about a business. It certainly includes directions through beneficiary designations on retirement accounts, life insurance, and even financial accounts at this point. In addition, as you had mentioned in the beginning, it's a combination of planning for your life and also planning for where you want things to go at your death. And so if you became incapacitated, having powers of attorney in place are very key for, you're still living and you just aren't able to manage your own assets or make your own medical decisions. And so that's why having the powers of attorney in place are so important. And then the planning on the death side is that when you pass away, where do you want your property to go? And that's, coordination of having your accounts set up correctly, and then having a will and maybe trusts that direct who is to receive your property and in what percentages and at what time. So it's not just having those documents, it's a coordination of all of those items.
So if I'm coming to my first meeting with you, what kinds of things do I need to bring to prepare for that first meeting?
So I really like to look and get a better picture of what you own and how you own it. It's not just a matter of, okay, I've got some joint bank accounts with my spouse, or, assuming you're married, or my house is, I have a house that's titled, but, a lot of people have pensions, retirement accounts, annuities, financial accounts, some property, some people own gas rights and business interests. It's a whole combination of understanding what that looks like and how you own it and who you may have it directed to go to. Sometimes, and we've had this, occasion where people get married, but prior to marriage, they had their parents on as the beneficiaries of, a financial account or maybe, a retirement account that they set up when they were first working. And so we like to go back, look at those items and make sure that when we put our plan together that we're coordinating who is the beneficiary, so that it coincides with the will that we're putting together. I think what a lot of people don't realize is that your beneficiary designations and your joint ownership of property, depending on how it's owned, they will control what happens to that property regardless of what a will or a trust says. So it's primary importance to also be reviewing and making sure that that is also up to date.
Oh, that's so good to know. So some people don't think they need an estate. There's common misconceptions out there. I hear it from people who are in their 30s and have invested in the stock market and done well. And I've heard it from young professionals who've got IRAs being set up or 401ks. What are some misconceptions about this? Why should everyone come to see you and talk about their wishes?
Well, again, as we talked about, there's this whole concept of intestacy in Pennsylvania. So if you
Which is dying without a will.
Dying without a will.
Okay.
And if you want to rely on Pennsylvania writing your will for you, then I
do not want to do that. No offense, Pennsylvania.
And so, I find that most people like to have control of where, of the things that they do, where things go. And without having it properly set up, it may not go to the people that you want it to. We've had definite occasions where people get divorced and they don't update beneficiary designations, or they forget to take them off, an account, and then pass unexpectedly. And now all of a sudden the family is fighting with the, divorced spouse as to getting the property back.
Right.
So it's an evolving process. What you need when you're first married and before you have children definitely is different than what you have or need when you're older, and you have adult children or grandchildren. And it also impacts, different styles of families. So if you have a second marriage where you have a mix of children from your first marriage and your spouse has children from their first marriage, how are we dividing property up? And also, if you have a child who has special needs, or even a divorce or creditor issue, that you want to make sure that they're protected. So it's very important to sit down and understand all of those dynamics.
Yeah, and that's what I've heard you're so amazing at, is really listening and finding out what could be at play and what we need to cover in these kinds of documents. Okay, so we've talked about the consequences of not having an estate plan. So I'm hoping at this point you know that you need an estate plan. How often should people review it and update it? You mentioned a lot of life events. Are there certain times that should trigger this other than National Estate Planning Awareness Month?
Well, it's a good time, I think, to be thinking about these moments. From our perspective, we generally tell people every 3 to 5 years, to just, revisit and look and see what you have and what you need. It also, obviously, if there's a significant change in your life where you've lost someone, where you've added a family member, those are definite good times to make sure that things are set up correctly. And, it could be at the time you did you started a new job and you added, your spouse on as a beneficiary of your retirement account, but you didn't have children at the time. So now we want to, change the beneficiary and update the beneficiary forms to say maybe to my children directly, maybe to trust under my will for my children. And so those are sort of the moments that, we discuss with clients as having a time to look back and make sure that what they've put together 10 years ago still works.
Right.
Sometimes, we also have that moment where you set things up when your children are very young and you have guardians appointed in your documents, and now your kids have kids of their own. And so guardians are probably not as necessary. So
one clause that I found so interesting in looking at a will has to do with if no one you're leaving your property to is alive. I forget if you call that the atom bomb or a clause or what, but and in that situation where none of your, I'm going to use the word heirs, are alive or designees, what do people need to do? What can they think about? Charities or friends? Does that normally happen? Is that a good thing to take care of?
Well, definitely, because again, under our Pennsylvania intestate laws, there's sort of a family tree of individuals who would inherit your property. So if you do not have a spouse, if your parents are deceased, if you have no children, it essentially goes out on, I say, to the branches of the tree. It might go to an aunt or an uncle or to, a niece or a nephew or a cousin. And that might be fine, but some people do have causes that they want to benefit if they don't have family who can receive their property. And so definitely if you want to leave anything to a charity or, to a good friend or someone outside of, your family tree, having that directed in your will or a trust, again, or a beneficiary designation is going to be key. And I think other thing that doesn't happen all that often, but I've seen once or twice in my career, is that very small family where the individual who dies, their spouse has already died, they never had children, they were both only children, so they don't have that, that extended family, and that the Commonwealth of Pennsylvania has inherited from their estate. It's only happened twice in my career, but 2 times too many, I would say.
So they didn't get to put their wishes out there if there was a charity or a university, or, I mean, I've heard of people who worked at schools, elementary schools, and left their entire estate to that school, and it's been so exhilarating and bringing so much happiness. So, yeah.
Yeah, I mean, I think that, again, in this one instance, there was a young man who was helping this elderly gentleman, and he thought he could just give him, this is way back when you used to have passbooks.
Passbook savings.
For the bank, and he handed him the passbooks to say, I want you to have these accounts, but unfortunately, just having control over the passbooks doesn't give you the right to inherit. And so when he went to try to transfer those accounts to him, that, the bank wouldn't allow that because there was no executor appointed to be able to make that transfer. And he didn't qualify necessarily because he was just, someone who was helping out. And unfortunately, again, everything went to Pennsylvania instead of to this young man who had been helping him for all these years.
Oh, geez. And I know we've all seen episodes of Law and Order or other shows on television where somebody is dying or in pain and unable to communicate their wishes, and they're not married. They just have a significant other. That person, unless it's in writing, has no say over the care of that person.
Well, right.
Their loved one.
You have to have, there are statutes in Pennsylvania that potentially, a significant other may have the ability to, to voice their, their position or to be able to make directions as far as care is concerned. But where you run into it is that when you potentially have, children from a prior relationship or prior marriage, who is not who you wanted making decisions for you. You wanted your other significant other, but they have that legal connection. They have that legal relationship, whereas this person doesn't. And so those are the types of situations where we will see, some conflict over who's getting to make the decisions and making the directions. And especially, I think, with a lot of couples who are either not married or same-sex couples, that even if they are married, I think sometimes there's pushback from other family members. And so if you have your directions in a written document, in a healthcare power of attorney or advance directive, or a financial power of attorney, so you're living, but you can't make these decisions for yourself, that person is the person you've directed and you've included in your documents to be able to make those decisions.
That's so important. I'm so glad we're talking about all this. Now, I hear the term trusts a lot. What role do trusts play in estate planning? You mentioned the children who are inheriting the $5 million right when they become of age. Should they have had trusts set up to protect them, or talk about trusts?
So, trust has a lot of different purposes. We're not going to get into, depth at this point about tax planning, but we use trusts a lot for, trying to minimize estate taxes. And also, on the inheritance side on Pennsylvania. But a lot of what we're using trusts for is just to assure that the beneficiaries who are going to receive your property receive it at an appropriate age. And that differs for everybody. It can be, just because you have a young child, you don't know what their spending habits are, or, who they might be married to. But it also could be, a child who has special needs, and by inheriting directly may cause them to lose benefits that they're receiving. And so a lot of times we're using trusts, again, for younger beneficiaries or even older beneficiaries who just can't manage their money very well. I'll tell you in the example that I was giving you, the young beneficiary, the one who's of age, who just inherited the $5 million, he went out and bought a very expensive automobile. And so, again, that's obviously a choice that he wants to make, but he's also decided that he's going to take some time off and go travel. And I'll tell you, $5 million is a lot of money if you invest it well, but if you start spending it and you're 20, 21 years old, it goes pretty quick. So I feel like, when you have young beneficiaries who haven't had those world experiences yet, or haven't finished college, or aren't at a point where they can understand how fast the money can go.
Yeah.
And that's why someone who would be appointed as a trustee can make those decisions and can guide them. I'm always a big advocate too when we do our trusts that we space out their distributions so that if they do get an inheritance and they do make a bad decision and maybe the money goes quicker than they expected, they have a second or third distribution. And hopefully they've, learned a little bit along the way.
Learned their lesson.
Yeah.
Let's talk about technology these days. I guess specifically the internet. How has that influenced modern estate planning from your vantage point? And, should people be going to the internet to write their will? Or I'll let you talk about that.
It's everyone is of that DIY.
Do it yourself.
Do it yourself. And it certainly is one of these moments where I feel like you do need guidance, whether it's from your attorney or from other parts of your team, as I call them. And so some people are doing investing on their own. They're doing their wills online. They're doing their taxes through TurboTax, and sometimes that might be fine, but what I've seen, at least on the preparation of wills, is that there are questions that people don't understand and they don't answer them correctly. And so they put a will together that doesn't actually work for them.
Oh, I see.
So I last week met with a couple who had done a will through one of those programs. And as I'm reading the will, it says, all of my estate goes to a revocable trust. And so I said, oh, well, do you have the trust document? And they said, oh no, we didn't prepare a trust document. And I'm like, okay, well, your will says everything goes to your trust. And if you didn't have a trust and have direction in your trust, now their estate became an intestate estate because they don't have a valid, direction in their will as to where their property goes. And the fallback to that is that you fall under the intestacy rules. So here they are thinking that they actually set up an estate properly using one of those tools, and it turns out they didn't.
So just filling in the blanks is not what you want to do.
No. And I mean, sometimes, you don't have it executed properly. Several years ago, we handled an estate of an older gentleman who just had, one of these mindsets. I'm not going to pay a lawyer to do my estate. I can do this on my own. And he tried a variety of ways, including using one of the online services. His document was never witnessed or notarized. Oh. And his family spent, I would say, about 5 years in litigation, spent over $90,000 in litigation costs. Where if he had, spent, $1,000 putting his will together, he could have saved his family a lot of headache. And in this case, he was not married to the woman who he wanted to leave his estate to. And so it was just a lot of conflict between his children from a prior marriage, the woman who he was living with, and spent an exorbitant amount of money. And nobody ended up, being happy. So those are the types of stories that are, reinforce that it's always good to have direction by someone who's, again, a professional who has dealt with similar issues. Mm-hmm. So I have seen them. They are lucrative for our litigation team.
Okay, well, I think that's enough of a warning right there. Yes. If litigation teams are getting involved with things you've done online, I'm coming to talk to you directly.
Exactly.
That's for sure. And your team, because I know it's not just you. You have a pretty sizable department now of experienced lawyers who've been helping people with this. So are there anything you want to say about probate? That term is so laced with, again, drama. I want to avoid probate. Right. What does that even mean?
In some jurisdictions in some states, probate is a very complicated and long and onerous process. And in Pennsylvania, it isn't so much. I mean, obviously during COVID, when, all of the Register of Wills departments were closed, you weren't able to probate. But in rare instances like that, in most cases, especially there's been some technological advances with the Register of Wills offices that you don't even need to appear in person anymore to get appointed as the executor administrator of an estate. But I mean, probate is essentially filing your will with the Register of Wills and having a legal representative appointed as part of your estate. And there are, administering estate has more involved than just the probate part. I mean, you still have to file an inheritance tax return to report assets and pay inheritance tax. But the probate system itself is not as, overwhelming as I think certain jurisdictions it can be. And so, you do hear, and I think it's more global. I mean, there are a lot of practitioners and professionals you'll see and hear on the television or on the radio that says, oh, you need to do everything to avoid probate.
Right.
And that may apply in different areas, but not so much in Pennsylvania.
I was going to say different states, different rules.
Right.
And in Pennsylvania, not so much.
I mean, it's still more efficient, to have beneficiaries set up and, to have, potentially if you have things held in a trust that will save probate. But I always tell clients who come in and I have to have a trust. I've heard I should have a trust. And I said, okay, well, it's going to cost you as much to put a trust together as it is in probate fees.
Oh.
So, and in the trust really only work really efficiently if you take the time to actually put your assets in the trust for it to work up, efficiently and appropriately. If you're not going to make any changes to your assets, having a revocable trust really does nothing for you.
Right. Okay, so this can be a very emotional time. Is there any advice you want to give to folks about how it's not as emotional as you think, or we can handle some of the emotions that come out when we're doing estate planning?
I think a lot of the emotion comes, especially with the appointment of guardians. You know, when you're working with a family who has younger children, and of course, trying to decide who would be the appropriate person to take care of your children if you died before they, were of a legal age, which is 18. And so that's a lot of what I think keeps people from getting their plans done, is that they say, we can't decide on a guardian. And I tell them, I'm like, well, here's the thing, is that you at this point in time have the ability to choose who that guardian will be, or who the executor will be, or whoever you're concerned, you can't make a decision on. If you don't put those documents in place and make those appointments and make those directions, somebody's making them for you. And it really may end up being not the person that you wanted. And so right now you have control, and while you have control, you should make those decisions. You should put your documents together versus waiting and hoping that you don't need them.
Right.
And that, somebody will be making the right decisions for you.
And the first meeting with you, is that an hour? What should people be thinking about?
I mean, I always set an hour and a half aside, to be honest with you.
Okay.
I mean, most of the time I feel like we can get everything done within an hour. But it's amazing when you sit down and you just, talk about different pieces that people aren't thinking about. Yeah. That it kind of goes a little bit longer, because I'm learning, especially with the first meeting, I'm learning all about, your assets, your family, your children. And, it's interesting how certain things come out in meetings, all of a sudden it's like, great Aunt Joni, left this in this place, and so from that perspective, I like to allot enough time that I get to really understand their picture, what they own, who their family is, the family dynamics, and then I can give better direction.
Right.
And also, again, sometimes it involves having some other of their members of their financial advisors, their accountants, or other people who are working with them, to get information and, to work with them as well.
So much information. I want to spend some time right now on how you can reach Lisa with any of your questions. Her phone number is 215-661-0400. So this is a great time with National Estate Planning Month to get your wishes memorialized. You can also reach Lisa at Shearman at hrmml.com. So thanks for watching, and we'll see you next time with more on Legal Talk.